Good evening to all who have joined this webinar organized by Taxmann. Today's topic is related to the place of supply under the GST. At the outset, let me clarify that this is, one of the very important topic under the GST regime, because this is one of the topic which are the foundation pillars of the GST. Because GST is a value-added tax system and known as goods and services tax in India. And value-added tax system is moving. All value-added tax system is successful only when the credit mechanism is available, and where the credit mechanism is strong and designed to carry the value-added tax system. In India, we had a mechanism for input tax credit, and that mechanism for transfer of input tax credit is running on the foundation pillars of the place of supply under the GST. So this being the fundamental and important topic, and there are so many provisions related to it. So let us start with the topic IGST. The first most question comes to in our mind is the GST is destination-based consumption tax, because it has been said that GST is the destination-based tax. If we are saying that GST is the destination-based tax, it means the earlier tax regime, the legacy, laws were basically the originate-based tax system. And to answer this question, we have to understand the difference between the earlier tax regime and the tax regime, the mechanism available under the GST. Earlier, as a central levy, when only for the comparison, I am taking the Central Sales Tax Act, because that was basically based on the structure of our country, like various states were levying the CST and collecting the taxes, although the statute was enacted by the central government. But that was being administered, and taxes was also being kept by the respective state governments. So federal structure, we were having the Central Sales Tax Act 1956, where the taxes were levied and collected by union and assigned to the state government. It was said that this was the origin-based taxation system. Why it was origin-based taxation system? We have to see the respective section 3 and 4 of the CST Act to understand how it was. And for limited purpose, still the Central Sales Tax Act is running, how it is the origin-based system. Under the GST, the tax is levied and collected by the union, but apportioned between the union and the state. That is, I am talking about the IGST, because the parallel law to the CST is the IGST. When there is a collection by way of CGST and SGST, so there is no doubt that this is going to the respective state government 50% and respective union government 50%. In IGST, they have said that it is destination-based taxation system, and for making it destination-based taxation system, we have section 10, 11, 12, 13 mainly under the IGST Act, which are making the law as destination-based taxation system. And to make it destination-based taxation system, one of the fundamental concept under the GST is the place of supply. And place of supply has been defined under section 2, clause 86 of the CGST Act, and which talks about and refer it to the IGST Act. And the IGST Act having section 10, 11, 12, 13, and 14. As per the self-determination, as per the self, which is enacted by way of IGST Act, and one of the fundamental purpose of enacting the IGST Act, the place of supply, so that the GST works on destination-based consumption tax system. Now, when we were having the section, going through the section 4 of the Central Sales Tax Act, it was basically saying that sale and purchase of goods shall take place inside the state, and it will be deemed to take place outside all other states, making it the origin-based taxation system, meaning thereby when a sale has taken place inside a state, suppose Delhi, then it will be outside of all other states, means only Delhi will be eligible to collect the tax on it. And if you see how they are identifying the state inside which the sale has taken place, that was as per the ascertained goods. If the goods were in Delhi at the time of sale, then the Delhi is the state where the sale is taking place inside the Delhi, and it will be all outside of all other states. It means Delhi was the state where the origin of the goods, movement of the goods was starting, and Delhi was collecting the Central Sales Tax Act. And slowly, they were trying to make it the value-added tax system also from 4% to 3% to 2%, but they could not reduce it from 2%, and it was basically creating the cascading effect so far as the taxation system in India prior to implementation of the GST was concerned. Then we came out with the Constitutional Amendment Act 101 in 2016 and the Article 269A, which was the part of the schema of the GST related amendments. And it gave the power to the Parliament to formulate the principle for determining the place of supply. And when a supply of goods or services or both takes place in the course of interstate trade or commerce, in the similar terms which the power was there to the union central government under the CST Act, under the Constitution to formulate the law of interstate sale. They have the similar power in GST also to define and identify the supply in the course of interstate trade and commerce. And further, Article 279, capital A, sub-article 4 states that the GST Council shall make the recommendation to the union and state, and one of the clause, the C, which is related, and it has been said that the principle that govern the place of supply. So it is on the GST Council to recommend the principle that govern the place of supply, and on the recommendation of the GST Council, those principles will be incorporated by the union government by way of the enactment, and that enactment is IGST Act 2017. So this is the genesis, basically the background that how the place of supply is very important and how the place of supply is going to play a vital role in the implementation of the GST. Now, coming to the second moot question is that what are the principles of place of supply under the GST? How we determine that particular supply, what is the place of supply? And if you see, the most important term to determine the place of supply is the location of the supplier, and second is the place of supply. To identify the place of supply and to identify the interstate sale or the intrastate sale, these two terms are most important, that where is the location of the supplier and what is the place of supply. Location of the supplier in case of goods is determined on different basis, and location of the supplier in case of supplier of services being determined in a different manner. And from here, you will see the difference between the supply of goods and services started. Otherwise, if you see the charging section 9, if you see the exemption, if you see the supply definition, the goods and services both are coming together. But once the question comes that how the goods will be dealt with and how the services will dealt with, the differentiation start, and we can say the destination of supply or tax is the place of supply, to understand where the destination of goods is, that is the place of supply. For example, if the goods is moving from Delhi to Ahmedabad, say Gujarat, earlier under the CST Act, Delhi government was eligible to collect the CST tax, and that was retained by the Delhi government also, making it the original based taxation system. But now if the goods is moving from Delhi to Ahmedabad, Gujarat, then the place of supply of that goods generally be the Ahmedabad, Gujarat, and that is the IGST will go in the account of the Gujarat state government only. And based on that, the IGST will be further distributed or will be available for the credit under the ITC mechanism. And now, one another question, very important question arises: what is the relationship between the claiming of the ITC with the place of supply? You know, India has adopted the federal structure. Federal structure meaning thereby all the state government have their sovereign rights, and union is there. Union have their sovereign right also, but some matters are assigned to the union government exclusively. Some of the matters are assigned to the state government exclusively, and some of the matters are in concurrent list. So like that, we have a federal structure, and Article 246 of the Constitution is the lawmaking power which makes the division between the union and the state and making it the federal structure. And the Article 246 capital A was inserted to enable the state as well as union government to simultaneously enact the GST law. So now when you see the relationship of ITC, the relationship comes as that the registered location of the recipient is very important, because it is the recipient who is claiming the input tax credit. The supplier is paying the tax as output tax, and recipient is claiming the input tax credit. And if the matching of these two is there, the recipient registered location is say Ahmedabad, Gujarat, and also the place of supply of that particular transaction is also Gujarat, then if these two are matching, then the input tax credit is available. Suppose in a particular transaction, when the registered location of the recipient is Ahmedabad, Gujarat, but the place of supply of that particular supply of goods or services is in the state of Delhi, then there is a mismatch. The place of supply is in Delhi, whereas the recipient is registered in the state of Gujarat. Then there are issues in claiming the input tax credit. And the input tax credit, I will show you the enabling section 16, which gives the eligibility criteria and conditions. This is, the basic foremost section which allows the benefit of input tax credit. It starts with every registered person. It means the input tax credit is available to the registered person. And if it is available to the registered person, then further comes that for the purpose of GST, registration is state-based. And there is a concept of, distinct person under the GST also. So each of the registration under the GST is treated as distinct. So meaning thereby, when the registered person term is used, the registered person in the same state in which the place of supply is falling, it making it generally eligible to claim the input tax credit. For example, in case of hotels being the immovable property, the place of supply is the state where the hotels are located. And even if the recipient is located outside the state where the hotel is located, but the place of supply will remain in the state where the hotel is there. In that case, there may be a mismatch. The recipient is registered, say, in the state of Gujarat, but the hotel is in Delhi, and Delhi CGST, SGST is the charge that is not available for input tax credit for the registered person registered in the state of Gujarat. This is coming out of the schema of the GST law. But recently in December 2022, there was an issue related to the transportation of goods for export. And issue was that there was a proviso to section 12(8), and that proviso says in case of the transportation of goods from India to outside India, the destination will be the place of supply will be the destination of goods. And in that case, the place of supply was going out of the Indian territory. Then the circular clarified the proposition that the said provision of law do not restrict availment of input credit by the recipient located in India if the place of supply of the said input service is outside India. This is, something different is explained in the circular, but this is related to only where the place of supply is outside India. It is not saying if the place of supply is falling in any state other than the state of registration of recipient, then also the credit of IGST will be available. It is not like that. It is only in respect to where the place of supply is falling outside India. So this is the diversion from the general rule. That's why I thought it proper to share with you. Now, coming to the provisions relating to the place of supply. If you see the provisions, I have already given you section 10, 11, 12, 13. This is the Bible for the determination of the place of supply. This is the, thing which say how to determine the place of supply for goods as well as for services. If you see section 10 talks about various situations. The one of the situation of section 10 is where the supply involves the movement of goods. Where the supply involves the movement of goods, then the place of supply will be where the goods terminate for delivery to the recipient. So wherever there is a termination, because this is the destination, you can understand the goods carries the GST also along with it. If it goods is moving from one state to another, the GST is also moving from one state to another by way of the IGST. When the goods is moving from Delhi to Ahmedabad, Gujarat, the general rule is that the place of supply of that goods will be the Ahmedabad, Gujarat, where the goods are destined. And second situation talks about where the goods are delivered by the supplier to a recipient or any other person on the direction of the third person. This is the situation where bill to ship to situation is there. We will understand by way of some example, and I will give you case studies relating to this situation. Further, another situation is where the supply does not involve the movement of goods. Where there is no movement, one can ask that if there is no movement of goods, how can be the supply there? Yes, there can be supply even if there is no movement of goods. Like in case of goods already there with the recipient, maybe on hire or on rent, some equipment or machinery has been given, but later on the supply has been done for the particular goods. Earlier, the renting of the equipment is the supply of service, but now it will be covered as a supply of goods. Then this clause will be applicable, and wherever the goods was located, that will be the place where the place of supply will be there. And where the goods are assembled or installed at site, friends, this is also very important clause where generally the mistakes are being committed. In many cases, there is assembly involved. And when the assembly is at site, that site will be the place of supply. And sometimes we forget to apply this proposition. So this is very important. And where the goods are supplied on board or a conveyance, including vessel, aircraft or train, etc., the place of supply shall be the location where the goods are taken on board. Where the goods has been taken on board to that train or to that vessel or aircraft, that will be the state where the place of supply will fall. And in such manner as may be prescribed, the rule-making power has been kept. Now, some of the critical issues related to the place of supply of goods. We take one case that A is in Delhi, send goods directly to C in Patna. There is a movement of goods from Delhi to Patna. And B in Agra gives direction to A for delivering the goods to C in Patna. It means that goods is moving from Delhi to Patna on the direction of B. B is the person who is giving the direction, and B is in Agra. Now C in Patna receives the goods directly from A. Now basically there are two supply involved. One supply is from A to B, A in Delhi to B in Agra. Another supply is from B in Agra to C in Patna. But what is happening? The goods is directly moving from Delhi to Patna from A to C. So in this case, the place of supply for first transaction from A to B will be the Agra, because this is the place of supply where the registered location of the recipient being B. For first transaction, the recipient is B. For second transaction, when there is an invoice or from B to C, then the place of supply of the second transaction will be the Patna, where the goods is ultimately lying. But in first instance, even if the goods is moving to Patna C, but the place of supply will fall in the state of Agra, being the recipient location, and which has been given in section 10, I have just referred. Just take another example. The similar kind of example, when the A is in Delhi and send goods directly to C in Patna, and B is also in Delhi and gives direction to A for delivering the goods to C in Patna, and C receives the good directly from A. In the same situation, but here the B is registered, B is there in Delhi. A is also there in Delhi, B is also there in Delhi, and C is in Patna. The goods has been delivered directly to C. In this case, there is a place of supply in Delhi for the first transaction. The supply will be from A to B. Both are in Delhi, and it will be leviable to GST and SGST. And then there is a second case from B to C, or there the place of supply will be Patna, and B will levy the IGST tax. So even if the goods has moved to Patna, but the place of supply in first transaction will be the Delhi. Now the third case we are taking the similar manner. If A is in Delhi, send goods directly to C in Delhi. Now the C is also in Delhi, A in Delhi. B is in Agra, give direction to A for delivering the goods to C in Delhi. And in this case, the C in Delhi receives the goods directly from A in Delhi. There is a delivery of goods from A to C, and both are in Delhi. In this first transaction, there is a supply from A to B, and it will be a place of supply will be in Agra. It will be an interstate supply, and the IGST will be charged by the A, even if the goods has been delivered in Delhi directly. In case the second transaction from B to C, again the IGST will be charged, and the place of supply will be Delhi. So this is the scenarios where bill to ship to situations are coming. We need to understand carefully while raising the invoice. Under the invoice rule, it is mandatory for interstate supplies to mention the place of supply on the cover of the invoice. It is a mandatory requirement. And if you see, the circulars has been issued to disclose the place of supply properly, because this disclosure is important for distribution of taxes among the states. Now coming to another situation, say now A in Delhi sends generator directly to C in Patna and assembled and installed there. B in Agra gave direction to A for supply and installation of generator to C in Patna. C in Patna receives the generator directly from A in Delhi. So now there is an assembly involved. When the assembly is involved, then the place of supply will be in Patna, where the goods are being assembled and installed there. This is the exceptional cases. This case has been created to say where the assembly is involved and the third person B is in the other state, then there will be a problem. And these situations should not be handled and bill to ship to cases, or either the B should be there in the same state, or there will be issue, and in this case the place of supply will be in Patna. Now another case, A in Delhi sells generator to B of Agra, and the generator is lying at work site of C in Patna. Now this is also a situation where the A is in Delhi, he is selling the generator to B of Agra, but the generator is lying at C. Section 10 clarifies when there is no movement of goods and the generator is in Patna, the place of supply will be the state where the goods is lying. B in Agra takes delivery of the generator at work site of C in Patna. C in Patna having generator at worksite owned by A of Delhi. So when the generator is in Patna, then the place of supply in this case will be the Patna, Bihar. And accordingly, we need to devise the mechanism so that the ITC is not disturbed and free flow of the credit is available to the recipient. These are the very critical cases where the ITC can be in question because the place of supply, if wrongly written, may lead to disallowance of the input tax credit. Now, sometime a issue comes about the ex-factory delivery or counter delivery or delivery at the supplier's place of business. Suppose the example which I am taking, that goods is moving from Delhi to Ahmedabad, Gujarat, but the Gujarat recipient has come to Delhi to take the delivery of the goods from factory of Delhi supplier, and he takes the delivery and he himself moves the goods from Delhi to Ahmedabad. Now the question is, what will be the place of supply in such cases? Because again, there is a serious challenges on the breaking of the chain of the ITC. If the place of supply is the delivery place in Delhi, then ITC will not flow to the purchaser, buyer, recipient located in Ahmedabad, Gujarat. But FAQ also, and also one of the advanced ruling in the case of Penna Cement Industries Limited, it has been held that it will be a IGST case, and it will be the case where the recipient is registered, even if the delivery has been taken by the recipient X site or X factory, but it will be the registered place of the recipient. Now, in these cases, it is very important when you are raising the invoice and writing the place of supply other than the state of supplier. When for example, supplier is located in Delhi and invoice is raised for a party registered in Gujarat. So supplier need to be cautious that on what basis the place of supply of Gujarat is being written when the goods has been delivered to the recipient in Delhi only. In that case, the registered RC is very important. In B2C cases, it is very difficult to establish that the goods has been delivered, goods has been destined for a state other than the state of delivery. But in case of B2B, the copies of RC is very important. Now, one more case, the Rajdhani Express from Delhi to Mumbai, and goods are taken on board at Kota, Rajasthan. And one of the passenger X is traveling from Vadodara to Mumbai. Suppose that food is served or that goods is given to Mr. X during the journey from Vadodara to Mumbai. So what will be the place of supply of that goods? Whether it will be Delhi or whether it will be Mumbai or whether it will be Baroda, Gujarat, or whether it will be Kota, Rajasthan. We have seen section 10, and in case of boarding the goods on board, taking the goods on board, it is the place from where the goods has been taken on board, and that is the Kota, Rajasthan. And in this case, the Rajasthan will be the place of supply for the supply of goods, even if that goods may be sold or may be consumed by Mr. X in Vadodara or during the journey from Vadodara to Mumbai. Now, these were some of the cases of the goods. Now we are moving towards the services. Services has so many, issues there. And in case of services, some cases it is very, difficult to identify what exactly the place of supply will be there, because advanced ruling authorities are also not in general taking the application for determination of the place of supply. It has been barred that the advanced ruling will not be pronounced on a question where the place of supply involved, and will be affected if there is a dispute regarding the place of supply. Now coming to some of the definition that who is supplier. Supplier in relation to goods or services shall mean the person supplying the said goods or services or both, and shall include an agent acting on such behalf. So agent is also a supplier, and supplier is supplier. It means what is the definition of agent? That is also very important, we will see. But agent takes foot of the supplier, that is treated as supplier. And place of business includes, the definition says that from where the business is ordinarily carried on. The place from where the business is ordinarily carried on is the place of business. But it includes the warehouse, godown, or any other place where a taxable person stores his goods. This is there where the goods are physically located, that is the place of business, or where the person maintains the books of account, that is also the place of business, and a place where the taxable person is engaged in business through an agent by whatever name called. If the principal is, doing business through agent, as I have told you, agent is covered under the definition of supplier only. So he takes foot of the supplier, and wherever the agent is doing business on behalf of the principal, that will be the place of business of the principal. And that needs to be taken care of. Now, location of the supplier of services. Location of the supplier in case of goods has not been specifically defined, but if you see the place of business definition, you get an idea that physically wherever the goods are being stored, that is the location of the supplier of goods. But in case of services, there are 4 clauses which Section 2, Clause 15 of the IGST Act defines about a place of business for which the registration has been obtained. If the registration has been obtained for a particular place, that will be the location of the supplier of service. And where registration has not been obtained, the fixed establishment elsewhere, that will be the location of the supplier. And further, where the supply is made from more than one establishment, the location of the establishment most directly concerned with the provision of the supply. When there is a supply, but the supply is being done by using the services of the more than one establishment, then the establishment which is most directly concerned with the particular supply. And in the absence of such places, the location of the usual place of residence of the supplier will be the location of supplier. So if there is no such fixed establishment, that's why in many cases, the individual working from home, the registration is taken at the place residence of the supplier, and that is covered under the definition of the location of supplier in case of services. So that is also very important. And then we have the definition of fixed establishment. This is important because where the registration has not been taken, where the registration is there, this fixed establishment is covered within the definition of the location of supplier, and based on it, the liability may arise for a particular supplier. And it says that which is characterized by a sufficient degree of permanence and suitable structure in terms of human and technical resources, that place will be treated as a fixed establishment. And fixed establishment is ultimately treated as a location of the supplier of services. Now, some of the critical issue so far as the place of supply of services are concerned. We take one case first. Mr. A in Delhi, owner of a godown, let out the godown to Mr. B in Mumbai. Mr. A is in Delhi, B is in Mumbai, and B takes the godown on rent for 1 month from A for rupees 5 lakh per month, and the godown is located at London, UK. This is one of the extreme cases we are taking to understand the genesis, whether in this particular case the section 12 will be applicable or 13 will be applicable. If you see in this particular case, section 12 is becoming applicable as a supplier and recipient both are in India, and the immovable property, the godown, is located in London. But if you see in this case, the place of supply is going at the location of the recipient, and that is Mr. B. And Mr. B in Mumbai, the place of supply is going to Mumbai, not in case of London, even if it is immovable property, because there is specific provision in section 12. Like we take another example. Mr. A is the architect in Delhi, provides services related to house of Mr. B. Mr. B is located in Singapore. House is located in Mumbai. Now, if you see, Mr. A is in Delhi and B is in Singapore. So in this particular case, section 13 is coming into picture, but the immovable property is located in Mumbai. Immovable property is located in Mumbai. In this case, the place of supply will fall in Mumbai. It is not like section 12, where the supplier and recipient both are in India. And the Mr. A will charge the tax accordingly, where the place of supply will be in Mumbai. Now, there is a difference between the domestic transaction and the international transaction, which I was just referring, but now clarifying it further that section 12 is applicable where the place of supply of services, where location or supplier and recipient is in India. But 13 is applicable where location of the supplier or location of recipient is outside India. If anyone is located outside India, then section 13 is applicable and section 13 comes into the picture. Now, if you see this section 12, there is a long section. Purpose here is to give some of the critical issues related to place of supply, importance of place of supply, which you should refer all this section while taking the decision, while identifying the place of supply in particular case. If you see section subsection 12 subsection 3, there is a proviso provided that the location of the immovable property or boat or vessel is located or intended to be located outside India. The place of supply shall be the location of the recipient. So in one case where the godown was located in London, but we said that the place of supply will be in Mumbai because the B was registered in Mumbai, B was there, location of recipient was in Mumbai. It is a different issue regarding the ITC, but it is an example to understand the concept of the place of supply. And if the immovable property will be located in more than one state, the proportionate place of supply will be there. But if you see the section 13, there is no like proviso and the place of supply will be there where the property is located. So in our case, when the recipient was in Singapore, but the property was located in India, so we said that the place of supply is going in India. This is finance. One important service is intermediary services, which is very confusing and sometimes it is difficult to understand the concept. First of all, we need to differentiate between the intermediary and the agents. First of all, this is judgment of Bombay High Court, recent judgment, where the divergent opinion of two judges were there, and then it was referred to the third member judge, and finally when the third judge gave the opinion, the matter was disposed of, and considering the fact, and they said that the 13(8)(b), which is talking about the intermediary services, is legally valid and constitutional. The virus of the section was challenged, and the Bombay High Court opined that it is legally valid. So this is the judgment. Now, coming to understand the difference between the agent and intermediary. The very important difference, if I can explain you in the single line, is that agent is nothing but the supplier. When there is a supply by a supplier or by the agent, it will be treated as supplier. But intermediary is not doing any supply. That is only facilitating the supply between one supplier to the recipient. He is in between only facilitating, he is not making any supply. But agent is practically making the supply. So that is a very big difference which we need to understand, and then only we can decide which particular section will be applicable and where will be the place of supply, that will be decided. Now, if you see the definition, you can go through in the presentation 2 clause 5 of the CGST Act, who carries on the business of supply or receipt of goods or services or both on behalf of another. The important point is who carries on. But in case of intermediary, he is not carrying on. He is the person of broker agent who arranges or facilitate where the facilitation or arrangement is there, goods or services or both between two or more persons, means there should be a supplier, there should be a recipient at least, and he should be the third person who facilitates the supply, but does not include a person who supplies such goods or services both on his own account that we have already covered. If it is on own account, he will be a supplier like agent or any other case. Now we are taking example, Mr. A in Delhi provides services related to booking of air ticket to Mr. B on commission basis. A is the travel agent who is booking the tickets for Mr. B, and Mr. B is registered in Mumbai, A is in Delhi, and airline is issuing tickets directly in the name of B. Now we are talking about the supply from A to B. A is commission agent charging the commission from Mr. B. We are taking only that case. Now, in this case, A is in Delhi, B is in Mumbai. Where will be the place of supply? Whether he is agent or intermediary. Now, in this case, the place of supply will be Mumbai, because this is a case where supplier as well as recipient both are in India. If both are in India, section 12 comes into picture, and in section 12, there is no concept of intermediary. Intermediary concept is only in section 13. So that is very important point. In case section 12, the general provision is the location of the registered person. It will be the location of that person. And in our case, the location will be the location of Mr. B, who is registered in Mumbai. Then in case the section 13, subsection 8, there is a clause B, which talks about the intermediary service. And this is the case where the place of supply is going at the location of the supplier. Here, there is a diversion. There is a concept is different. The place of supply is generally going to the place of recipient, but here the place of supply is going to the location of supplier. And this is in case of international transactions. We need to understand that place of supply in this case is going at the place of the supplier. Now, matter came with Delhi High Court in case of McDonald's India cases. The department framed the case like the intermediary service. In detail, you can study it's a recent case, and the High Court opined that there is no reason for covering this in the category of intermediary, and they opined that this is a simple case of export of services, and this is a simple case where the intermediary concept is not applicable. In the same way, Netgear technology case also, the case was referred back for the fresh examination, and the benefit of Ernst & Young was allowed, and the adjudicating officer will take care the judgment passed in case of ENY and Omi Industries Asia Pacific. These are the very important judgment where the concept of intermediary has been discussed. Now, some of the cases relating to transportation of goods, and that is very important. If you see section 12(8), in case of transportation of goods where the supplier as well as the recipient is in India, it is generally the registered person where shall be the location of such person, where the registered person is located. The registered recipient is located, that will be the place of supply. This proviso which was creating problem, and the circular which I referred December 2022, where the ITC was allowed even if the place of supply was going out of India, foreign territory, then also the input tax credit was allowed by way of circular. But this proviso has been omitted, and that has been omitted with effect from 1st of October 2023. Recently, it has been notified, but it is effective from 1st of October. From 1st of October, the place of supply, the invoices will not write as the foreign territory. They will write the registered location of the recipient, and the problem will be sorted out at all. But till 30th September, you can take the benefit of the circular and take the input tax credit, even if the place of supply has been mentioned to be the out of India, foreign territory. So this is very important. And if you see section 13 also, there was anomaly, and they were saying about the destination of such goods. So they have removed it. And in case of international transactions also, where the freight forwarder is located out of India, even if he is providing the services of export, then also the ITC will flow, even if the tax is paid on RCM basis, and ITC will flow in these cases also. And this subsection 9 has been removed, and that is omitted with effect from 1st October 2023. And in case of section 13, the general law will be applicable, and general law is that shall be the location of the recipient of services. So if location of the recipient of services is in India, even if the goods is moving out of India, the place of supply will be the location of the recipient, that is in India. If a freight forwarder in Delhi is supplying services of export cargo, and the recipient is also in Delhi, the place of supply will not go to out of India. If by way of section 12. But even if the freight forward is out of India, section 13 is also, the general provision will be applicable, and that is also amended. Now, some event management services, there is an overlapping of many provisions. We need to take care very, carefully, because in this case, there is a lot of confusion so far as the subsections are concerned. If we talk about section 12, that is where the supplier as well as recipient both are located in India. And if we discuss the case of subsection 5, place of supply of services relating trading and performance appraisal to registered person shall be location of such person. So training and performance appraisal, that is a different service. If you see subsection 6, that is a by way of admission to a cultural, artistic, sporting, scientific, educational, entertainment event or amusement park or any other place, and services ancillary there to share shall be the place where the event is actually held. Now the question comes, what is educational event and what is training? If there is a training, the place of supply is going at the location of the registered person. But if it is an educational event, then the place of supply is going to a place where the event is held. Now we need to differentiate between the event and the training. If it is a training and performance appraisal, then subsection 5 will be applicable, otherwise subsection 6 will be applicable. So thin difference. In the similar manner, if you see subsection 7 of the same section 12, we will find that organization of cultural, artistic, sporting, scientific, educational, and entertainment event. This is organization. This is not admission. So this is an event management company who is organizing the event on behalf of any company and raising the invoice, then it will be the organization. When it is organization of the event, it will be to a registered person, then it will be the location of such person. And if he is not registered, then it shall be a place where the event is actually held. So now we need to understand, if the recipient is not registered, it will go to the location where the services are actually provided location wise only. But if the recipient, the company, corporate, or the organization who is organizing, who is owning the event, and the event management company is an organization, then this will be there. Further, if you see the section 13, Section 13 categorically says in case of admission or organization of both, in both the cases, sporting, scientific, or entertainment event, it shall be the place where the event is actually held. So ultimately 13(5), the word is being used even for both the cases, whether it is an admission or whether it is an organization. So this need to be taken care of. Now, some of the illustration relating to tour operator services, if we take a case that ABC Travels in Delhi provides tour operator services to Mr. A, and Mr. A is unregistered and resident of Noida, and for where the tour is there, the tour package is provided for Europe. If you see, this is a case of Section 12 because supplier ABC and recipient Mr. A both are in India, and the provision relating to Section 12 will be applicable. And as per Section 12, the location of the recipient will be the place of supply. And another case we are taking where the ABC Travel in Delhi provides services to Mr. Z. Mr. Z is a citizen and resident of Australia, and package tour is related to India and covering Rajasthan and Delhi, maybe. Now the situation is different. Here the supplier ABC in Delhi, India, and recipient Z is in Australia. Now Section 13 comes into the picture, and when 13 comes into the picture, it comes within the performance-based services that we will see. If you see, the definition of tour operator has also been provided under the Act. And under the notification, there is a definition who's the person who is engaged in the business of planning, scheduling, organizing, arranging tour, which may include arrangement of accommodation, sightseeing, and other similar services. Basically, when we are talking about tour, it's a package tour where the accommodation and sightseeing and similar services are already a combo. It's a package. A la carte services are covered differently, like passenger transport service, like hotel or guest house services separately, and all other services separately. But in case of package, it will be treated as a tour operator. The Section 12, which I was referring, the general rule, it will be made to a person other than registration person, shall be the location of recipient where the address on record exists. If the address is there, it will go to the recipient location. Otherwise, it will go to the location of the supplier. And in case of, Section 13, Section 13 is very important. And you see the service supplied to, there is a clause, subsection 3, clause B, individual represented either as a recipient of service or as a person acting on behalf of the recipient, which require the physical presence of the recipient or the person acting on his behalf with the supplier for the supply of service. So in case of tour package given to the foreign tourist, but the location is India, so he is physically required to be present in India, and this is being covered under this clause. And in both cases, whether a foreign tour is provided to Indian citizen or Indian tour is provided to foreign citizen, in both cases, the GST liability is coming. And this is subsection 7, this which talks about the division when more than one state or union territory is involved, like Rajasthan and Delhi. So that is the case where this. Now, I think I tried to cover. Time is short and time is closing now. And so few of the questions are there. I think now I would like to interact and take up some of the queries which has been raised by the participants here. And being a very interesting topic, I would suggest everyone to go through, and it is a fundamental topic. Thank you very much for hearing me. I am just starting the question answer. One of the question is that what if the supply is made to employees of SEZ entity by any hotel accommodation service? There is a circular also, there is a clarification also. If it is covered as an authorized operation, it will be an interstate supply. Even if the immovable property, the CGST, SGST should be there. But in case of supply to SEZ, all supply to SEZs are interstate supply as per Section 7, subsection 5 of the IGST Act. That is basically the situation. What is the place of supply of B2B supply of banking services? B2B supply of banking, it will go to the registered recipient. Where the recipient is registered, there the place of supply will be there. If the registered person is in Delhi and having the GST number of Delhi, so it will be a general rule only. Can a person make supply of services from a place other than place of registration of such supplier? You know, if there is a supply from any other place, that will be covered within the place of business, and there may be a liability to take registration there. So it is there. We need to see whether it is a case of goods or services, whether it is like a temporary arrangement is there, or there is a fixed establishment. If there is a fixed establishment of service, then their registration should be there. If it is not coming within the definition of fixed establishment, then the supply will be treated as being provided from the registered location. So it depends on the facts of the case, that other than place of registration, if supply is provided, if there is a sufficient permanence, that will be treated as fixed establishment, and you may be required to take the registration for that particular premises also. I think I tried to answer the question posed here. If there is any other question, what would be, one more question is, what would be the place of supply by GTA transporter if the supplier and the recipient are in different state registration, but supply is made to the state of supplier? Whatever I am able to understand from your query, supplier and recipient are in different state of registration, but supply is made to state of supplier. Means there is a transportation within the state of supplier only, but if it is on behalf of the recipient, the place of supply will go to the registered place of the recipient only. The general rule will apply, thus it will go to the registered location of the recipient. If we are talking about the Section 12, if we are talking about general rule, it will go to the registration as per subsection 8 of 12 also, because proviso has been now deleted, omitted, and this case will be with the registered location. After Mohit Munral Supreme Court judgment, I think it's good you have asked, because for the due to prosperity of the time, I could not take up this ocean freight. Is GST on import freight is removed from RCM notification list? The answer is no. They have not removed it. It is there. But if you see, after the Supreme Court judgment, RCM can be there in two cases, where the different terms of contract is there with the recipient. If the freight is being charged by the foreign supplier, foreign exporter, then it becomes the composite supply and there is no need to pay the RCM. But if there is a separate terms of agreement with the recipient in India and the transporter outside, ocean freight shipping line outside India, then the RCM will be required to be paid. But so far as this particular question, it has not been removed from the list yet.